I have a voice recording of my review of a case that was put before the Supreme Court of Texas, or rather in the judicial branch of Texas, that was referred to an administrative proceeding as a way of explicating the difference between what qualifies for consideration before the court versus what's appropriate for an administrative hearing. I have my own argument contesting some of the findings of that case. But I also understood in the summer of 2018 that the Texas Insurance Commission has a process separate and apart from and distinct from the judicial process in consideration of claims regarding insurance, including insurance fraud. My understanding is it did not negate and it did not waive a right to trial by jury, but that it was a separate and distinct process through which one could attempt to seek redress. I first contacted the Texas Insurance Commission, or rather, the Texas Board of Insurance Commissioners, in May of 2018. At the time, a gentleman by the name of Kent Sullivan was in charge of the board, and the instructions for how to contact them for a review of a claim was to contact the head of the Board of Commissioners directly. That was to whom I addressed my first effort in late May, early June of 2018. I had need to follow up on that after I was sent a response that is dated for June 4th of 2018 that gave me a case number. Now I am going to review. According to what is currently available on the official website of the state of Texas that provides the electronic records of what is current law, the codes that I invoke in a later effort to contact the Insurance Commission on July 23rd of 2018 are still actively identified as current law concerning insurance and the insurance code. However, there is something that is what I've suspected for a while that did not become apparent till right now. And unfortunately, the first option that came up was not what I had cited, but what it seems somebody swapped it out with and has been attempting to use to their advantage since then. So I'm going to read the document. It is my own composition. If there was any confidentiality involved, unfortunately, it has now been over 3 years. And they are, by their own terms, not only in default because of the specific motion or the specific reference I'm going to read, but they are in default in other terms as well. And the implications are quite harrowing. I am not going to lie. I'm actually in shock, personally. Uh, this report is a follow-up to report number 2018-report number, verified on June 4, 2018, concerning a June 1st, 2018 report by Charity Colleen Krause. The Texas Board of Insurance Commissioners is requested to consider if per section 427.051 subordinated indebtedness, if any cash, cash equivalents, or other assets, including pending or awarded recoveries for prior fraud reports beginning in March of 2016, revisions to Krause's credit rating after successfully challenging fraud concerning a credit account with Chase Bank, or intangible assets, including biometric data or abstract assets, were used to assist funders financiers of the 10 days of detention at the Neuropsychiatric Center in West Oaks Hospital in qualifying for program requirements concerning advances on loans. It is additionally requested to see if this detention then substantiated or qualified later assets, including information in public information reports on crimes used as securities by affiliated agencies, networks available for access via association by virtue of participation in network of program providers, including connected abstract or other intangible assets, or potential insurance carriers or beneficiaries available by virtue of participation for use in qualifying for advances on loans. I then go on to quote Texas Insurance Code section 452052 regarding subordinated liability permitted. It also says that as a result of this, there are specific requirements regarding documentation. I request, per section 427.053, approval of agreement required that they provide the actual copies of the documentation approving not only the authorization for the treatment, but the financial information about who was billed and who was supposed to pay for the treatment, which by law, according to this section of the Texas Insurance Code, they were required to provide me. I also cited per section 427.055 to be payment of principal or interest on certain liabilities that they consider, if any of these billings that were used in connection either with the actual medical treatment or in the association with the alleged services provided at any of the shelters I was diverted to, that if any of that was used in consideration of any financial obligation associated with me, or if it was connected to any consideration of a loan, including use of me or assets associated with me as part of that loan, then I also request consideration of section 546.0013A, genetic information, regarding any genetic information that was involved in any acquisition, transfer, evaluation of, or billing for services, which per the code is required by law for them to provide me. And I also cited section 546.1033B, exceptions to confidentiality, regarding my efforts to contact somebody who identified himself as working with a major insurance company in the course of a medical reinsurance effort for his assistance with my understanding that there were other insurance providers that were leveraging or that were being identified in the course of what was alleged to be medical treatment. I also cited section 83.051, authority of commissioner to issue order, requesting an emergency cease and desist order in response to certain acts of harassment and intimidation that were going on, as well as theft of my identity that was being used for illegal purposes. And I also cited section 83.052, notice regarding the Texas Board of Insurance Commissioners' requirement to present a formal charge within 30 days from the date of the report. This report. Now, the report I sent this on was dated for July 23rd of 2018. Unfortunately, by August 22nd of 2018, I was where? By August 22nd of 2018, I had been evicted from the living arrangement that I had at that time in Fort Worth and required to be transported to Dallas before 30 days was up. I had to even file a police report with the Fort Worth police because I had been threatened while I was in that indoor living arrangement. And twice I had to contact credit bureaus because somebody was accessing my electronic account information and altering it, including in efforts to try to compel me to engage in concurrent actions that I did not agree to and considered and understood were illegal. Before the 30 days was up, I was threatened with physical violence within 24 hours of that. Another woman was threatened with violence involving a motor vehicle. She had to file a police report. I had to file a police report. The police refused to provide me with assistance in getting my stuff from the place, which means all of the stuff that I had there ended up getting stolen. And I was forced to wait overnight outside at the train station until I could get a train back to Dallas because nobody in Fort Worth would provide me with assistance. This did not, under any circumstances, in any way, shape, or form, adhere to the legal requirements regarding the Texas Board of Insurance Commissioners to give a formal charge in regards to a demand in consideration of award of restitution or consideration of the other codes that were invoked regarding their responsibility to provide documentation that there was actually authorization for what was alleged to be medical treatment. And until this time, nobody has responded to any of my reports, including to the Texas Insurance Commission, but also through the judicial branch of government or any legislative branch of government. Here's the alarming thing. See, I had noticed after I found an old book that there were significant changes to the Texas Insurance Code on September 1st of 2001 that had impacted insurance code going all the way back to the 50s. And that one of the things that happened, and that had been happening at least since I had been trying to find information beginning in 2016 regarding the insurance code in Texas, were that all of this specific information regarding, for instance, how reserves are compiled based on group insurance policies for people that work for political subdivisions that themselves are a part of consideration of the financing for municipal bonds, all of that had been cut out. That was no longer available. What instead was available were all of these references to insurance for motor vehicles and all of these considerations of car insurance, where the more substantial comprehensive considerations of different kinds of insurance, including insurance that people that were involved with public financing or that were attempting to get some sort of, shall we say, assistance through a publicly financed program, up to and including all three branches of government, well, that had been removed. And what instead it seemed to be were all of these reliances on derivative insurance claims involving car insurance, right? And things of this nature. I did not know this until right now. I cited a specific code in here under the insurance code. The insurance code is section 546.001, genetic information. That's under the insurance code. I'm looking right now at the site. On the site, under section 546, subchapter B, genetic testing and use of test results. That's here. Section 546.051, 546.052, improper use of test results, refusal to submit to testing. Section 546.053, testing related to pregnancy. I did not cite all of these, right? But I cited the first two, 546.052, 546.051. Well, here's the problem. Under the Texas Transportation Code, Chapter 546 is operation of authorized emergency vehicle and certain other vehicles. You mean like towing cars during a declaration of a state of emergency as a substitution for genetic information? Genetic information got substituted out for operation of authorized emergency vehicle? And you've literally just been trafficking me ever since I filed a report with the Texas Insurance Commission. And rather than responding to the actual request for a report, which by the way invoked considerations of a hearing, an actual in-person hearing regarding the charges, what I'm finding instead is what? Compilations regarding workers' compensation for domestic workers. You mean like while I was in Fort Worth, the effort was made to try to characterize me as if I was assisting a disabled veteran who threatened me with violence and forced me to have to leave while I was in the course of trying to get restitution through the court system and or addressed legal matters concerning the court system, and I had filed a claim with the Insurance Commission. So over and over again, I have been trafficked to 5 cities in Texas in 4 years. And every time I make a claim, you kick me out, even though I've been consistent in what I'm trying to do. And you award a kickback to somebody else you already predeterminately positioned to attempt to extort or entice me into cooperating with their illegal crimes. When I got kicked out of Fort Worth, it was after trying to stay there for a month's time with somebody that was recurrently engaging in escalating crimes, including crimes that didn't make any sense at the time. I had to file a police report. They refused to respond to the police report in an appropriate manner, but I've already tracked how they used that police report as some form of derivative action connected to speculation on the police pension system that has had fatal consequences, and not just internationally. It's over 3 years since I filed that request for a hearing, and today, you want to let them report today, 3 days after August 3rd, after the clearing of the 72-hour period, where you would have had a chance to request a reconsideration on any sort of equity claim. Your equity claim would be 17 vehicles that were stolen and taken to a chop shop. What does that say about the genetic information of me and those other women that were in that domestic violence shelter, that were threatened unless we agreed to take medication we did not need or give children medication they did not need? Is that your verdict? Are you actually going to address the charges? Because those are the charges, and even through your completely illegal derivative action, that's what you've proven. That's absolutely what you've proven. This is not the kind of thing you continue to allow for people that refuse to take responsibility for what they're literally doing to continue getting away with.